Hi everyone, and welcome to a real estate educational series with Anna Stepchenko. I'm a real estate professional from Miami, Florida, and decided to create this series with two main purposes: educating and informing my audience on basic yet very essential real estate topics. In today's topic, we will be discussing deposit disputes with real estate contracts. When do deposit disputes arise? Who is entitled to a deposit if the transaction falls through? What steps must be taken in order to protect yourself from losing the deposit? To obtain answers to all of these questions, I came to the law offices of Andrew Tarr, a renowned real estate attorney with over 26 years of experience, whose practice involves anything that has to do with real estate. Hi Andrew, how are you?
I'm doing well, Anna. How are you?
I'm doing great, and thank you so much for taking the time and doing this interview with us today.
My pleasure. It's nice to be back with you again.
Thank you. So my first question will be, based on your professional experience, what are the most common reasons for deposit disputes with real estate contracts?
Oftentimes it's a result of people not paying attention to timelines in the contract, whether it's a timeline relating to inspections, could be timelines relating to financing not coming through, and there's little problems that develop even if financing looks like it's coming through, but it hasn't actually occurred. Or typically it's what we call conditional approval. And conditional approval is exactly what it sounds like. It's not a complete and total approval. There are conditions placed on the approval, and people might find themselves in an uncomfortable position if those conditions cannot be fulfilled. Sure. But they've already gone beyond the time that the contract allows them to get financing approval. So that in and of itself could give rise to a dispute.
Sure. And what would you recommend, I guess, to realtors, to buyers and sellers, to anyone who is involved in a transaction to avoid this kind of issue?
The easiest way to make sure you're on point and on target for everything to close correctly is to have a timeline set out in the beginning, a lot like what you do critical timeline checklist. And when you do get an approval, you got to keep the sellers informed of the loan process. And when you get your approval, make sure that it's a final approval. In other words, there's nothing that could happen that the lender could say, oh, we can't close this transaction now because we didn't get this. So it's up to you to be proactive with your lenders, and when your lender says you're approved, get it in writing and make sure that there are no conditions that you might not be able to fulfill in the event that it's a conditional approval and you don't know that it is.
So it reminds me of a popular phrase that time is of the essence. So I guess it's a very applicable saying pertaining to the real estate contract, that everything is time is money, basically.
100%. And the contract itself actually has a provision that says time is of the essence. And what that means is exactly what it sounds like. It just means that all of the time periods that are identified in the contract mean something. And it's not just, oh, well, we don't need to worry about that. The fact is that you do. So if there's a time period for a 30-day loan approval, that doesn't mean 31 days. That means 30 days, and you need to know when that 30-day expires.
And it has to be communicated with each party of the contract, and worst case scenario, they just sign an addendum.
Yes, of course, and the addendum would extend all applicable time periods in detail so that you understand exactly what you're extending, not just the closing date.
Absolutely. And my second question will be, especially here in Florida, we deal with a lot of cash deals that have no financing contingencies. So in this type of real estate transaction, what other common reasons for deposit disputes exist?
Well, when you're dealing with a cash transaction, the buyer does not have as much, I would say, of an opportunity to get out of a contract because there's no lender approval required. So really what the buyer is doing is they're saying, I'm committing myself and my deposit to purchasing this property on the closing date, subject to only an inspection, let's say. And the typical inspection period would be 15 days. Other things that could potentially get a buyer out of a contract that might otherwise look binding would be if the buyer never received condo documents or homeowner association documents when it's required for the seller to give that to them.
And that's actually the third question that I wanted to ask you, the condo docs, because we deal with so many condominiums here in Florida. And in the condo rider, most of the buyers put a check mark that they want to review the condo docs, and they have by law 3 days to review them and get out of the contract if something is not right. But what happens on many occasions, from the experiences of other realtors, thank God I never had to deal with that, but what happens is that these documents are never delivered to the buyer. So let's say the financing has been obtained, the condo association approval has been obtained, the inspection period has been taken care of, and this inspection came out perfect. And let's say they have 7 days before closing and the documents were never delivered. So if people receive documents, if the buyer receives the condo docs, let's say 7 days before closing, and something doesn't look right, legally speaking, he can cancel the deal, correct?
Sure. I mean, when you buy in a condominium in particular, you're buying into a whole set of rules and regulations, and there's something called a declaration of condominium, which is like the Constitution. So sure, you're agreeing to abide by that. And there's also a budget. And that budget is going to be a very important consideration for buyers because it tells you the financial condition of the corporation that is the condominium. So you want to make sure that if there is a major repair, that the association has, for example, reserves, or that if there is a major repair, what might it cost you as
sure,
the buyer or the new owner? And typically it's going to be a prorated share of whatever your common element interest is in the condominium. So it's not a lot of money, believe it or not. $1 million assessment sounds like a lot of money, and it certainly is a lot of money, but it might not cost the individual unit owners that much money, and the condominiums will typically give the buyers time to pay that off. But before we even get to that, the buyer needs to know what they're getting themselves into, which is why Florida law, as you stated correctly, is a 3-day, basically like a waiting period where you can review everything. And once you've received all of the documents, if you don't like what you see, you can opt out.
That's why the sooner you receive them, the better. So it's always good to encourage the listing agent and the seller to provide them ASAP so that nobody loses time in a transaction.
Yes, and I mean, you and I have talked before about little differences in contracts and the nuances and what I might change depending on who I'm representing. And if I'm representing the seller, I want to make sure that the buyer checks off not only that they say that they want it, we know that they want the documents, but that they have received the documents. And I would even itemize what they've received so they can't ever come back and say, well, you never gave that to me. If I'm representing the buyer, honestly, buyers sometimes don't look at these documents, but I'm not all that bothered if they're not provided on time, because it gives the buyer a way out.
Absolutely.
And I know that doesn't sound great, but it's a possibility that the buyer might need to avail themselves of in the future.
Because life happens.
Exactly, and I just like to keep that possibility open if I can.
Absolutely. Andrew, so if the deposit dispute actually arises, what do we do from there?
It's a good question, and one thing that everybody needs to understand is even though the contract might be very clear as far as how the dispute process works, and frankly it might give you a good indication as to who is right and who is wrong, neither the realtor nor the closing agent or the escrow agent or any of the attorneys involved can ultimately make that decision. So the process as outlined in the contract is that you have to make a demand to mediate the dispute. And mediation is a non-binding process where you have a neutral third party who listens to both sides and tries to get everybody to agree. And if you cannot come to an agreement at the mediation, then it's going to be something that has to go into court. And the rules might be a little bit different if a real estate broker is holding the deposit, but typically I'm the one who likes to hold the deposit so we can go directly to mediation and to court. But ultimately it could be a judge who's making the decision. So another tip that I might give you is when you're closing a transaction, keep notes and make sure that you are complying with all of the terms of the contract and make sure that you can prove it. Pretend like everything you're doing is going to be told to a judge, and you want that judge to know clearly what your side is and that you've done everything that you need to do.
Well, Andrew, thank you so much. It was a very informative interview, and to sum things up, could you please give our audience major key points as per what parts of the contract they should pay attention to avoid forfeiting the deposit?
Well, Don't be in breach of contract is your best way not to forfeit the deposit. Do your research before you buy and enter into a contract. And when you have an inspection period, whether it's 15 days, which is the default in the contract, or whatever else you might specify, take the time to do the research that you really need to do in order to determine that this is the unit for you or this is the property that you want to buy. That's one certain way to not forfeit a deposit. And make a checklist of all the timelines. Work with a realtor like Anna who knows the business backwards and forwards and can certainly guide you every step of the way. That's probably the most valuable tip that I can give you, is work with people who know what they're doing.
And my tip would be that time is of the essence. Please remember that and make sure to follow the time frames. Thank you so much for watching. Have a great day, and we will see you soon.
Keep in mind that buying a home is a very important decision, and I am available to answer any questions that you might have throughout the process. I'm available for a free consultation, and I'm happy to guide you every step of the way.